Welcome to an oral argument session with the 5th DCA. As a reminder, we are being recorded on YouTube. On the panel with me today, I have the privilege of sitting with Judge Nardella and Judge Eisnagel. And we have one case this morning. It's 21-143, Jeremy Scott Cayo versus State of Florida. Ms. Fant will reserve 5 minutes for your rebuttal unless you indicate otherwise.
Yes.
Okay, and with that, you may proceed.
May it please the court, Andrea Fant on behalf of the appellant, Mr. Jeremy Scott Cayo. In this case, the issue stems from voir dire. The judge commenced voir dire with instructions on burden of proof and presumption of innocence. Specifically, she went over that issue about 3 times. Also, during the state's voir dire, they asked the court to specifically read the jury instructions on burden of proof and presumption of innocence. So by the time that I commenced my voir dire, the potential jurors had heard the burden of proof and presumption of innocence about 4 times. I asked the question, what would you require from the defense? There were 20 potential jurors, and I asked each one. Every juror said that they would require some form of rebuttal or evidence or arguments. It varied from each potential juror. I commenced the entire voir dire, asked all 20 jurors, and then at the end of voir dire, I then asked the court to strike the entire panel because of their responses to my question. That's when the court brought each individual juror in separately, and then we questioned them again. The court attempted to rehabilitate them by asking them, or simply just saying, the state has the burden, the defense doesn't have to do anything. Do you understand that? And she would repeat that 3 or 4 times sometimes, just back to back, and then ask me to repeat my original question. So I submit to the court that the court's efforts to rehabilitate them were unsuccessful. These jurors initially expressed bias by saying that they would shift the burden over to the defense to present some evidence or some argument or some rebuttal. And only after coming back into the court individually and hearing the court say, the burden is on the state, the defense doesn't have to do anything. Now, Ms. Fant, repeat your original question. So naturally, I would repeat my original question, and then the jurors would backpedal and say, oh, well, for the instance in juror number 5, specifically, his initial response was he said he needed to hear witnesses and see evidence in order for me to make a determination. When asked individually, after the court said the state has the burden, the defense doesn't have to do anything, he changed it and said, well, maybe I used the wrong choice of words before. My
question is, it seems from the record that the court characterized their initial responses as responsive to a vague question that they misunderstood rather than an expression of immutable, firmly held convictions. What is your response to that finding or observation?
Even if you find that my question was general and vague, you can't disregard their responses. When, for instance, juror number 15 says, you have to make me believe he's innocent and sell it to me, that's a belief system. And you can't ignore that, specifically because the law says that if there's any reasonable doubt as to whether they would be fair and impartial, you're supposed to err on the side of caution and strike them as opposed to risking it and leaving any doubt as to their impartiality.
Isn't that a rule, though, for the trial courts to apply rather than our standard of review on appeal?
I realize that this court looks at the record and what the record establishes, and I submit to the court that the record establishes that these jurors were not rehabilitated.
And is that argument applicable? Are you arguing the panel overall, or is your argument really each individual juror said something that disqualified them?
That's correct. Each individual juror answered my original question, and everyone exposed bias by saying they would shift the burden to me in some form or fashion.
Which is the strongest case you have as applied to which juror? Do you think it's most clear?
I think there are a few. Juror number 15 saying, "Make me believe he's innocent and sell it to me." And then only after the court repeated, "The state has the burden, defense doesn't have it to do anything," then she said, "Okay, well, then I won't require anything." I think there's reasonable doubt there. I think also juror number 5, who said he needed to hear witnesses and see evidence in order for him to make a determination. Those were his words. I didn't put those words in his mouth. I didn't feed that to him. Those were his words.
Ms. Fan, I'm sorry. In this case, what is interesting to me, and I haven't seen any cases similar in this respect, is that we actually had a trial on 2 different charges, correct?
Yes.
And in this case, on those 2 different charges, the defense did not present any evidence and the defense did not call any witnesses.
Correct.
So our fear for juror number 5 is that he doesn't understand that the defendant does not have to call any witnesses and does not have to present any evidence. Yet, didn't juror number 5 come back and acquit on one of those counts, belying the presumption that he may not have understood? And if that's true, what should we do with that?
They did. Mr. Kao was charged with both battery, domestic violence, as well as assault. They acquitted on assault and convicted on battery. I still submit to the court that they held on to their convictions. They held on to their belief system. And when we did not deliver what they needed, maybe there was a compromise. Who's to say? I still submit that they held on to their convictions.
Would it be improper?
Counsel, I mean, what evidence do you have of that? I mean, assuming that what the jury ultimately did after you presented absolutely no evidence, assuming that that's relevant to our inquiry here, I mean, what evidence do you have that they just reached a compromise instead of actually applied the law?
Well, I don't have any evidence of that. I was not in the deliberation.
Is there anything in the record that would even suggest that?
I believe their initial responses suggest that. I believe.
But then the verdict, I mean, doesn't the verdict speak a little bit louder than their initial responses, which may well have been just confusion about the way you asked the question?
I don't believe so.
Why not? Why wouldn't the verdict itself speak louder than what may have been just confused jurors?
Well, their verdict was split. They still convicted on the battery charge. And given the responses that I heard, and that's clear in the record.
If they were going to demand you to present some evidence and convince them, then by definition, they would have convicted on both, correct? Because you didn't present any evidence.
I would not concede to that.
Well, explain it to me then, counsel. I just don't understand how the two match up.
I don't believe that simply because they held on to their convictions that they could not have gone into the deliberation room and made some compromise. I don't know what happened in the deliberation room. All I know is that the record was clear that they were going to shift the burden to me. And when I didn't deliver, Mr. Kao was convicted on a battery.
Ms. Fan, I wasn't able to find any case law where we had this unique factual scenario where there were 2 counts, one an acquittal and one a conviction. Are you aware of any?
When I did my research on this particular issue, I couldn't find that. So I presented the cases that I found that were applicable to this issue as best that I could.
Counsel, at what point is it simply a reasonable conclusion by the trial court that you asked a confusing question in a very vague way and that the jurors were simply confused by it? I mean, they're lay people, they're not lawyers. Would it take 100 jurors being confused for that to be obvious? Or at what point,
it's not a number, but even if it's confusion, the court's efforts to remedy that were insufficient because all that the court did was keep repeating the same statement over and over, and then never asked the jurors after that, do you now understand? What is your understanding now? She just simply repeated the same statement and then asked me to repeat my original question. So if there was confusion and she was trying to clear it up, that still didn't clear it up. There's still reasonable doubt as to whether they were just repeating what she had told them to say or whether they had an understanding. There was still a doubt as to that.
Why
Ms.
isn't that in
I
an,
understand your concern. My question is, doesn't it help the state in this case that the judge gave the floor to you to ask the follow-up questions instead of the judge or the state then proceeding to ask leading questions?
I'm sorry, can you repeat?
I'm sorry, that was not well worded. But in a lot of the case law that we're dealing with where the jurors are being rehabilitated, it's the court which is reminding the jurors of the law, which they may be doing, multiple times because it's unfamiliar to them. But then the case law which seems to run afoul, it's either the court continuing after they remind them of the law to then ask leading questions where you see a juror capitulate, or the state asking leading or confusing questions after a juror is reminded of the law and then the juror capitulates. Here, doesn't it help the state's case that after the trial judge reminded the juror of the law, that the floor was given to you to ask follow-up questions?
No.
Instead of, okay. Go ahead.
I disagree with that. And I disagree with that because in the manner that it was done. When we reached juror 4, first, I was told how I could phrase my questions. So I had started to ask a question or started to have a dialogue, and the court asked us to approach the bench. And I was specifically told, this is how you need to word your questions. This is how things need to be done. And then the sequence of events, it was the court repeating the same statement and then saying, okay, now Ms. Fant, you ask the original question and remind them of their original statement. That's the manner in which I was instructed to do it.
Counsel, that was your question. The court, why wasn't the trial court simply trying to clean up the confusion created by your original question, which does seem pretty vague to me?
The efforts on the court, if there was confusion, the efforts on the court to clean that up, I submit to you, were unsuccessful. Simply just repeating the same statement and then instructing me to ask my original question, it coaches the jurors into what they need to say, that their first original response was incorrect and now they need to change it. It was clear that that's what they were doing because they had an authentic response to my question.
How could it be authentic if they were confused by a vague question that had essentially very little context?
I believe it's authentic because of their word choice. I simply just asked a question and then they responded. So if
you asked a vague question with very little context. And so why, sure, maybe it was a genuine response to a vague question that lacked context, but I'm not sure that helps you much, right? Because they're answering your question, which was vague and lacked context.
If my question was vague, or my question was simply, what would you require from the defense? They could have said nothing. They could have said we were not required anything, especially given that they had already been instructed on the law and read the jury instructions. They could have just simply said nothing, but all of them went into detail as to what they would require from me. So I submit that even if there was confusion, it wasn't cleaned up. Simply the manner in which it was done and asking me to repeat my question after it had been repeated several times, sometimes 3 and 4 times back to back, that's simply coaching them that your first response was not accurate. We want you to change it. And I submit to you that that's clearly what they were doing, because in the case of juror 5, I need this in order to make a determination and then to backpedal later and say, oh, I used the wrong choice of words. That's not the wrong choice of words. They're just submitting to what the court is asking them to do.
Let me ask you this. So let's say juror number 5 walks into the courtroom that morning, and juror number 5, not being a lawyer, being a layperson, thinks that, well, I personally think that both sides should present their arguments, and I'll take the best one. That's what they think, being a layperson. And they firmly believe that that's the way it should be. But then they're instructed by the trial court, no, that's not the way the law is. The law requires something very different than that. Despite the fact that juror number 5 walked into the room that day with a firm conviction that both sides should present their evidence, doesn't the law simply require that juror number 5 be willing to apply the law as instructed by the trial court, despite their personal convictions?
I believe the law is clear that you take all of the circumstances. You don't negate what they've put forth first.
So if juror 5 says, I personally believe that we ought to have a system where both sides present their evidence and they're required to present their evidence, and then we just take the best of the two. But I understand that's not the law. The judges told me that's not the law, and I believe in applying the law, so I will do it as the judge has instructed. That juror would be not qualified to sit.
I believe under the circumstances, the court could make a decision, but you would not be able to negate his original statement. You would not be able to disregard what he said first and take his last statement in isolation.
Ms.
So
Fant,
that's
you have
strict-
about
that-
4 minutes. Sorry, you have about 4 minutes remaining if you'd like to reserve, unless Judge Eisner would like to continue.
And under my theory, under my hypothetical, would juror number 5 be stricken if it went that way? The transcript went that way.
If he later changed his position,
If he said, I believe the system should be different, but the judge tells me this is the law and I'll apply the law as the judge tells me.
under that limited circumstance, I would argue that they should be stricken, whether or not the court would agree with me. But I would not be able to negate his original statement that he would require something from the defense.
Essentially, if defense lawyer can ask a vague question, get a juror to say the wrong thing, there's really no rehabilitating that then at that point, right?
I
In
believe
your view?
I believe you can rehabilitate. I think you have to ask more questions. I don't think that you can rehabilitate based off of how the court did it in my particular case. Some of the cases that I've read in preparation for this case, I do believe that those jurors were rehabilitated because there was an extensive dialogue, there was conversation. You could clearly see that they were coming around. But in my particular case, where the court just simply repeated 3 and 4 times, the state has the burden, the defense doesn't have to do anything. Now, Ms. Fant, repeat your question and let's see if they change. That to me did not rise to the level of the cases that I read where the jurors were rehabilitated.
Ms. Fant, when you come back, can you answer this question when you come back? And that's this: as to jurors 12, 4, and 7, can you point me in your initial brief where you argue that they were not properly rehabilitated? And that's just as to 12, 4, and 7.
Okay.
All right, thank you. Mr. Palace?
Thank you, Your Honor. May it please the court, my name is Richard Palace. I represent the state of Florida. It's simply our position that the motion to strike was properly denied. There was no abuse of discretion, no manifest error in all the trial court's findings, that there was no reasonable doubt that these jurors could be impartial. As stated by the standard, they're fairly supported by the record. This was an ambiguous question. It was open-ended. The jurors all answered in kind, and it's noteworthy that the first 2 jurors to ask, I believe, were jurors 8, followed by jurors 6. After the trial court had ordered the defense to structure its question in a certain way, both of these jurors were stricken for cause. Their answers stayed the same after stating they required this. All these other jurors that were not stricken, they were merely giving TV answers. I mean, they hear, what do you require? They're going to say what they expect the defense attorney.
Counsel, I mean, look, the appellant's counsel says, look, I mean, they had already been instructed on the law. It's not like they hadn't been instructed on the law, right? It's not like this question was asked in a complete vacuum, right?
Well, yes, Your Honor. It certainly wasn't a complete vacuum. The trial court had covered the law earlier. The state covered it during their voir dire. And admittedly, the defense prefaced this question with saying we wanted context regarding this. But then we bring in these jurors, and some are just asking for argument. Some are stating to maybe cross-examine witnesses. But just because, when I was a youngin' and my mother told me to do the laundry, even when she told me 4 times, I sometimes didn't do it until the 5th. I don't believe that just because they heard these instructions, these jurors as lay people had already internalized this and were a blank slate that knew with every question they would get, they would have these instructions in mind. And of course, they were given these instructions again before it was time for deliberations when the trial court had charged the jury.
Do you know the answer to Judge Nardella's question about whether this has ever been applied where there was a conviction on one count and an acquittal on another, and a jury found been biased?
Well, Your Honor, I looked through case law and I cannot say that I found a case specifically. I know I found cases where even when a juror was an alternate, there was still an issue with them not being stricken for cause and the like. Someone who doesn't even deliberate necessarily. In terms of this case, in my opinion, this serves almost more as evidence that none of these jurors that were selected for the panel, 5, 9, 12, 13, 14, and 15, that they harbored this kind of bias because they applied the law. They decided that the facts did not match the charge for assault, for domestic assault.
Counsel, isn't that kind of like an after the fact sort of analysis? And maybe that's proper, but why is that a proper analysis? If the juror should have been stricken initially before trial even began, why should we look at the verdict to say, oh, well, essentially, I guess that would be sort of like a harmless error sort of analysis, maybe?
Yes, Your Honor. And it's understandable that obviously at the time, the case law does not allow harmless error for these juror issues. These are usually per se reversible. I know that out of the recent Divine opinion that came out of our Supreme Court, 3 of the justices had concurred, wishing to backtrack from certain case law regarding this per se reversible error and instead apply DiGiulio in situations such as this, where jurors were still stricken and were stricken for peremptory challenges, but were not stricken for cause. Of course, admittedly, that is not the law right now. A plurality opinion wouldn't apply to us in this case, Your Honor. I'm sorry, Your Honor.
What do you do with the case law that talks about equivocation? So after we instruct a juror on the law and they don't give a firm response that they understand or that they can implement the law as instructed. And so particularly I'm interested in juror number 7, who after he's instructed again is asked by the state whether or not the defendant has to do anything. And he questions, he says, they don't have to say anything. And then the state says, are you okay with that? And juror 7 says, well, yeah, I guess. Then the state says, would you hold it against the whole defense team if they did absolutely nothing while I put on the entire case? Juror 7 says, I'm going to say no. The state says, are you sure? And then juror 7 says, it's suspicious. And the questioning continues from there. But doesn't that show a degree of equivocation which cuts against the state's argument?
Well, Your Honor, I agree that it shows a degree of equivocation, but I believe it's still equivocation that was solved in this, especially because when they talk about the defendant disputing or counter-arguing, he begins using terms such as, it would be nice, I would expect it, it would be helpful. I think the trial court was able to observe this demeanor, and it's fairly supported by the record that based on being specific, this would be helpful, I would expect this, and then, of course, saying he would not hold it against the defendant. because
But counsel, it seems like that is a phrase that was used a lot, right? Would you hold this against the defendant if the entire team said nothing? Would you hold it against? Is that the same thing as saying, hey, I wouldn't require, I would still acquit if the state didn't meet its burden? Is that the same thing? Saying, hey, I wouldn't hold it against the defendant?
Well, I believe that saying you wouldn't hold it against the defendant is basically the opposite end of saying I would hold the state to its burden. Yes.
Well, it seems just as vague as appellant's counsel's initial question, right? That was vague. It seems when we say, well, would you hold it against them? That seems pretty kind of vague too.
Well, of course, with juror number 7, given that the initial question was vague, I believe for rehabilitation, we sometimes had to get into the nitty-gritty of how they necessarily feel. Here we're trying to expose whether they have a preconceived, guilt for the defendant here, whether they're prejudging him, whether they're shifting this burden. Saying that you're not going to hold it against him, while of course, admittedly could be more arguably stated by saying you'll hold the state to its burden and only the state to its burden. You will not hold a defendant to its burden. I think that because sometimes this voir dire got conversational, I don't believe that it brought us into vagueness territory, Your Honor.
And how much of this do you think is demeanor that only the trial court could observe? For example, wasn't juror 4 stricken specifically because of his demeanor coupled, or I'm not sure the gender of juror 4, but juror 4's demeanor coupled with that juror's words. So I guess what do we focus on? Is there a phrasing of an answer that clearly disqualifies a juror on our review based on this record, or should we be looking at it through the lens of whether it's clear, that the trial court should have dismissed the juror based on that statement?
Well, Your Honor, I believe it could be a mixture of both. In the cases where, of course, reversal was warranted because these jurors had a preconceived notion of guilt, in those ones, they would specifically say, I would not consider him innocent, or I'm not 100% certain I could consider him innocent, such as some of the cited case law. And in those, when they're being rehabilitated, they would say, I would probably apply the law, but I would probably prejudice this defendant based on how I feel. I believe that might have either been the Lowe case or the Huber case regarding the juror who had children and didn't feel comfortable dealing with a sex battery case. But I believe coupling that along with how the trial court observes the demeanor and how the questions were posed. Unfortunately, this is a cold record. We don't have full video view of how these jurors were acting when they were answering these questions. I know juror 4 specifically was, the for cause was denied with that juror, but that juror was stricken by a peremptory strike. But I believe juror 19 is a good example of this, where the trial court said that they should be stricken for cause, where juror 19 would completely flip his answers over and over again. He required proof, evidence, wanted to show weakness in the testimony. He specifically said, convince me. After the jury instruction, he first says, I would need proof from the defendant. He then went on to say, bring the state to argue. And he kept flipping. And the trial judge said that observing his demeanor and how his answers were flipping, he did not believe him when the state when he was asked, would he hold it against the defense?
And I'm sorry, I apologize. I think I meant to refer to that juror instead of juror 4.
Oh, no problem, Your Honor. The way you're describing it sounded very much like this juror. I know that with him, I read that transcript and I just found he was very confused because he would say something one way and then he would be to side B. You'd flip the coin back to side A. And in the end, he said, while he said I would not hold it against him, the trial court expressly found when addressing who the trial court was planning on striking for cause before they went to peremptory challenges, observing him, the trial court didn't believe it. I believe that, unfortunately, I don't give you a great answer for this, Your Honor, but this being distinguishable from the cases where it's clear that there's a preconceived notion of guilt, or they're shifting the burden, or this juror just flat out will not be impartial, coupled with here it being a more equivocal answer and question. And then, of course, the court going through its rehabilitation of the jurors. I believe in that case, this record supports, or I should say fairly supports, as stated by the case law, that this would not rise to jurors that should have been stricken for cause. If this court does not have any other questions, I will rely on my brief, and I ask that you affirm.
Any other questions from the panel? All right, Ms. Fant,
Thank you.
I have about 2 minutes remaining. Thank you, Mr. Palace.
So just to address the court's question, juror number 7, yes. Juror number 7 said ultimately is suspicious. Those are the words that she said when asked, could you not hold it against the defense if they didn't present anything? Juror 12 said he wanted evidence and arguments that my client is not guilty, and then still stood firm on I needed to present an analysis of the evidence, even when the court stated that if we didn't have to do anything, would you hold that against the defense? And juror number 4 is the one where everything kind of became different, because with that juror, you can see it took a lot longer. That was the one where the court asked me to approach, where she said I couldn't ask certain questions. You can see that I initially started to remind him of what his original response was. And she said, don't remind him what his original response was, just ask your question. So for him, I argue that he was never rehabilitated. He kind of seemed conflicted with the idea that I didn't have to do anything. He kept asking if she did nothing, if they did nothing. He kept asking that question of the state. So I submit to you that those 3 jurors were never rehabilitated. In terms of demeanor, there's a few. Juror number 15, juror number 18. Juror number 18 was on the verge of crying. The court just dismissed that as her being embarrassed, even though I specifically asked her, is this still your belief? Do you still believe this? And is this still your position? After the court readdressed her. So I submit to you that the manner in which the court attempted to rehabilitate was insufficient. These jurors were not rehabilitated. They showed bias, and there was still reasonable doubt as to whether they could be fair and impartial. Thank you.
Thank you, Mrs. Fant. Thank you, counsel. That we're adjourned.